Welcome back to This and That about international law and sustainability, where we break down the legal system shaping our environment, our rights, and our future. I'm your host, Shunye Wade, attorney, professor, and scholar. Today, I want to start us off with a question that sounds almost backwards. What if the Supreme Court, in the name of protecting Congress, actually becomes one of the most powerful environmental regulators in the country? Yeah, sounds wrong, doesn't it? The Supreme Court does not issue permits, it doesn't set emission limits, or conduct environmental reviews. Its formal role is to interpret the law. But that is precisely where the power lies. When the court decides what an environmental statute allows and what it does not allow, it can determine whether an agency has authority to act at all. That is the paradox at the heart of the recent Supreme Court decisions we'll discuss today. And together, these cases are not only about environmental regulation, they are about who gets to decide how environmental laws actually work. Their effects are now becoming clearer as we've had this precedent set for some time. Agencies are reinterpreting their authority, states are carrying much more of the regulatory burden, and courts are increasingly deciding which level of government may act. To understand that shift, we need to first understand a very fundamental aspect of United States of American governance, and that is cooperative federalism. The basic idea is straightforward. The federal government and state governments share responsibility. Congress passes a law. The EPA sets national standards, supports and approves state programs, as well as steps in when implementation falls short. States do much of the day-to-day work, issuing permits, inspecting facilities, and enforcing standards. So even under federal environmental law, the frontline regulator really is often a state body. And that is not a side detail. That is by design. The Clean Air Act works this way. So does much of the Clean Water Act and many other pollution control statutes and programs. And that structure makes sense, right? Because environmental problems are rarely just local or national. Air crosses borders and water moves through connected watersheds. The federal government therefore establishes a federal or national floor, while states administer programs on the ground in their specific jurisdiction. And some states also go further than the federal law requires, like California. But cooperative federalism only works if the cooperation is real. States rely on federal funding, research, expertise, and stable standards. If Washington transfers responsibility while withdrawing that support, partnership begins to look like an unfunded mandate. And that's an issue we don't want to deal with because there's a constitutional limit on how this partnership can be structured under the anti-commandeering principle. It cannot force states to enforce a federal law or run a federal regulatory program. Funding is one of the main tools that makes this voluntary cooperation possible. Congress can offer states money to carry out federal priorities. Federalism usually avoids the problem of commandeering by giving states a choice: administer an approved program with funding or allow the federal government to step in and regulate directly. Reducing federal support is not by itself unconstitutional commandeering. Not saying that, but it can make that choice less meaningful, especially when the federal government is also weakening its own ability or willingness to serve as the regulatory backdrop. And against this already fragile backdrop, the Supreme Court has shifted the legal ground beneath federal agencies. The first case we'll discuss is West Virginia v. EPA, which was decided some time ago in 2022. The case involved the Clean Power Plan, which addressed carbon emissions from existing power plants. Under Section 111, the Clean Air Act allowed the EPA to identify the best system of emission reduction. The agency interpreted that language to permit an approach known as generation shifting, essentially shifting electricity production away from higher emitting sources and toward cleaner ones. The Supreme Court rejected that interpretation under the major questions doctrine. The basic idea of this doctrine is that when an agency claims the power to decide an issue of extraordinary economic or political significance, it must point to clear and explicit authorization from Congress. Broad statutory language may not be enough anymore. Supporters see this doctrine as an important safeguard, right? Agencies should not be allowed to discover sweeping new powers in decades-old statutes, particularly when those powers could reshape a major sector of the economy. But here's the difficulty. Congress often writes environmental laws and other broadly for a reason. Congress cannot anticipate every new technology, pollutant, or future crisis. It relies on experts and agencies to apply existing law to scientific and industry change. After West Virginia, agencies must ask more than whether their interpretation is consistent with statutory text. They must also ask whether a court might consider the issue major, and if so, whether Congress authorized this precise form of regulation clearly enough. And that gives the Supreme Court an enormously consequential role, right? By deciding when an issue is major and how clearly Congress must speak. The court also shapes which environmental solutions remain legally available or unavailable. And so in 2022, West Virginia set the tone for the cases that followed. The second case is Sackett v. EPA, decided in 2023. This case dealt with the Clean Water Act, and more specifically, which wetlands count as waters of the United States, or WOTUS. That phrase matters because it defines the geographic reach of federal water protection. If a wetland is covered, filling or dredging it, or discharging it with pollutants may require a federal permit. If it is not covered, the Clean Water Act does not apply, and then protection is largely left to states, tribes, or local governments. For years, one of the key standards that was used was called the significant nexus test. Under that approach, a wetland could be protected if it had meaningful effect on a covered body of water. It did not necessarily need an obvious surface connection. The connection could be ecological or hydrological. A wetland might filter pollutants before they reach a river. It might store flood water or help support the health of a larger watershed. That is why wetlands matter. They are not just wet dirt. They are a part of an ecological infrastructure. But in Sackett, the Supreme Court said, to the heck with science, and rejected the significant nexus test. They adopted a much narrower rule. The majority held that a wetland is covered only when it has a continuous surface connection to a body of water that it itself is protected, making it difficult to tell where the water ends and the wetland begins. Supporters of this decision say this gives landowners greater clarity and certainty. And that concern does matter. People should be able to determine whether federal law applies to their property, especially when violating the Clean Water Act can carry significant, serious consequences. But the environmental concern is that water does not always behave in ways that are obvious to the naked eye. A wetland can affect water quality, flooding, and the health of a watershed, even when that connection isn't the most obvious on the surface. It is also important to understand that although all 9 justices agreed that the EPA lacked jurisdiction over the Sackett's particular property, they did not all agree with the majority's narrow rule. 4 justices argued that the Clean Water Act also protects wetlands separated from covered waters by features like berms, dunes, or levees. In Sackett, the court chose the narrower boundary, and when federal protection recedes, the responsibility does not disappear. It shifts to states, tribes, and your local government, whose laws, resources, and political priorities vary significantly. Next, we have Loper Bright versus Raimundo, decided in 2024. And this case is a real game changer, and not just for environmental law. The case itself involved a federal fisheries program, but the court used it to reconsider a doctrine that had shaped administrative law for almost 40 years, the Chevron deference. The basic idea was this: if Congress had answered a question, then the court followed Congress. But if the statute was ambiguous and the agency's interpretation was reasonable, the court generally deferred to the agency. That did not mean agencies always won. And it did not mean that they could do whatever they wanted. It meant that when Congress left room for interpretation, agencies had some breathing room to make policy within that space. And that made a lot of sense, especially in environmental cases, because agencies work with technical records and scientific information. They review scientific studies, receive public comments, and they really get to see how these statutes operate in practice. Judges are experts in the law, yes, but they are not usually hydrologists, climate scientists, or quality engineers. In Loper Bright, however, the Supreme Court overruled Chevron. The court held that judges must exercise their own independent judgment and determine the best reading of a statute. An agency's interpretation may still be persuasive, yes, especially when it rests on technical expertise or a long-standing interpretation. But courts no longer and can no longer simply defer because the statute is ambiguous. Supporters of the decision see this as a restoration of the proper judicial role. Agencies are a part of the executive branch, and courts should not simply accept an agency's interpretation because Congress wrote an ambiguous law. In their view, it is the judiciary's responsibility to say what the law is. But the concern is that environmental statutes are filled with broad terms like reasonable, necessary, appropriate, and best available. Applying those terms often requires more than reading a dictionary, and it's very time sensitive. It requires scientific judgment, technical knowledge, and sometimes a choice between competing policy approaches. Now, Loper Bright does not mean agencies have no discretion. If Congress expressly gives an agency authority to make a particular judgment, courts must respect that delegation. But ambiguity alone is no longer treated as an implicit delegation of authority to an agency. So instead of asking, is the agency's interpretation reasonable? Courts now ask, what is the best reading of this statute? And that alone moves significant power from agencies to judges. The dissent warned that this would create instability across the federal government. And that concern is not difficult to understand. When agencies no longer receive deference, disputes over ambiguous statutory language become new opportunities for long, protracted litigation. Different judges may also reach different conclusions about the best reading of the same federal law. Courts also had a role in reviewing agency action already. But after Loper Bright, their role is different. A court is no longer primarily policing the boundaries of a reasonable agency interpretation. It is deciding for itself what a statute permits. That does not merely change who interprets environmental law. It changes who has the final say over how adaptable a law can be and which actions fall within scope. The fourth case is Corner Post versus the Federal Reserve, also decided in 2024. Corner Post was not an environmental law case. It involved a Federal Reserve rule governing debit card fees, which is interesting in and of itself. But its reasoning applies across all administrative law, including environmental regulations. Under federal law, administrative law, a person generally has 6 years to bring an Administrative Procedure Act, APA, challenge. The question in Corner Post was, 6 years from when? The government argued that the clock began when the agency issued the rule. But the Supreme Court held that the clock begins when the particular plaintiff is injured by the statute. And that distinction matters. A business that does not exist when a regulation was adopted may be able to challenge that regulation years or even decades later, once the rule begins affecting it. Supporters of the decision say, a person should not lose the right to sue before that person has even been injured. And honestly, that is a powerful fairness argument, right? But the regulatory concern is stability. An agency can no longer assume that a rule is largely insulated from this type of litigation merely because 6 years has passed since it was issued. A new plaintiff may create a new window of litigation at any time. And, right, when we combine Corner Post with Loper, right, the consequences become even more significant. Older regulations may face new challenges at the same time that the courts are reconsidering the statutes behind them without Chevron deference. To be clear, Loper Bright said that prior decisions upholding agency actions prior to Chevron are not automatically overruled. Ordinary principles of precedent still apply, but Corner Post creates new opportunities to challenge rules that have been generally considered resolved. Taken together, the pattern is clear. West Virginia demands clear congressional authorization for major agency action. Sackett narrows the reach of federal water protections. Loper Bright gives judges greater authority to determine what statutes mean. And Corner Post allows some newly injured plaintiffs to challenge long adopted and solid rules. The court says it's doing this to protect Congress from agencies claiming powers that were never given to them. Congress rarely updates environmental statutes every time science, technology, or environmental conditions change. So when the court demands that Congress have greater specificity in its laws while also claiming final authority over statutory ambiguity, power does not necessarily just return to Congress. It may mainly move to the judiciary. And now we can see this judicial shift reshaping environmental governance in real time. In February 2026, the EPA rescinded the 2009 endangerment finding that had provided the legal basis for regulating greenhouse gas emissions from new motor vehicles and engines. The EPA described its new position as the best reading of the Clean Air Act and pointed to recent Supreme Court decisions like West Virginia and Loper Bright as part of the changed legal landscape to justify its rescission. States are now challenging that interpretation in court. We can see a similar struggle over California's vehicle emission standards. California has long received federal waivers allowing it to enforce standards stronger than federal requirements. But the federal government has recently treated several of those waivers as rules that may be overturned under the Congressional Review Act. California disputes that interpretation, and those challenges are also before the courts. I'm not going to unpack either dispute in detail today, but they illustrate a larger point. Federal deregulation does not necessarily return power to the states, and limiting agency authority does not necessarily return power directly to Congress. Instead, these disputes increasingly end up in court. That is not simply deregulation. It is a redistribution of authority, increasingly with the judiciary. The Supreme Court is not regulating the environment in the traditional sense. It's not measuring pollution, writing permits, or selecting pollution control technologies, but it is increasingly controlling the legal boundaries within those decisions are made. So, back to our original question. Who controls the environment in America? The formal answer is that no single entity or institution does. Congress writes the laws, agencies implement them, states administer many of the programs, and courts review government action. But the practical answer is changing. The institution that defines the boundaries of everyone else's authority exercises enormous control over the system. And right now, the one claiming that role is the Supreme Court. Now, that does not mean that environmental law is dead or that agencies and states suddenly become powerless. But it does mean that the terrain is changing. In the next episode, we'll examine how this shift is playing out through the rescission of SEC's government-wide NEPA regulations and the EPA's rescission of the endangerment finding. These two taken together show how quickly the federal environmental framework can change, even when Congress hasn't repealed the underlying laws. If you found this episode insightful, please like and subscribe. Until next time.